Thank you, and it's always great to be at a CSG function. And I think each of you who participate in this organization understand that this is a very special organization that serves the purpose of recognizing the role, the important role that states play in the formation of public policy in our country, and we need to promote the role of the states in doing that. And one of the ways CSG has historically engaged in that activity, certainly not the only way, but one of the ways is through interstate compacts. And if you look at the major interstate compacts, those that have large numbers of states, and in some cases regional compacts as well, you'll find that in the historical paperwork of those compacts, going back to the initial legislation that was drafted and was crafted by the various stakeholders, Council of State Governments has regularly played a role in the process of developing these interstate agreements, and rightfully so, because compacts are a way that our founding fathers have devised very presciently in our federal Constitution for states to achieve the goal of uniformity without surrendering sovereignty. And what usually happens when somebody wants to create a policy solution where we have 50 different states with 50 different sets of rules? Too often, people look to Washington, D.C. and erecting some new bureaucracy on the Potomac to govern us. That doesn't have to be the case in order to achieve uniformity. And in our Constitution, our founding fathers recognized in the original document through the Compact Clause that states can exercise their sovereignty collectively in order to achieve the kind of uniformity that some think can only be achieved through federal preemption. So let's look to frame the issues today of solutions for healthcare professional licensure in the context of compacts at a little bit of history and a little bit of background to frame the issue of what compacts are, how they function very generally, and without undue detail, what sort of the legal foundation is for these instruments, and then get into the specifics with each of our other speakers. First of all, compacts, as all of you know who are legislators, are statutes, but they are statutes which also are contracts, except the parties are not private parties or corporate entities, they are states. So a compact is both a statute and a contract, and for that reason, these compacts take on a special status in our legal system with respect to legislation. And because they are contracts between states, they have a status in the law that is unique, and we'll talk about that in just a minute. But in order to achieve uniformity, in order to achieve economies of scale, in order to speak with one voice collectively as states, frequently compacts can be used to achieve all of those objectives. Compacts are not the only means of interstate cooperation, certainly, but they are a very effective one. As I said, we go back to 1789 to the original Constitution, and we find that long ago, our founders recognized that states should be able to exercise their sovereignty in that way. And the way that they did that in the early period of our history, in fact, before the Constitution was ratified, was through boundary disputes that arose among the 13 original colonies. We saw that in our last session that North Carolina is enjoying its 225th birthday, and as one of those original 13 colonies, some of the boundaries between those colonies would be settled by interstate compacts. So they've been used that long, and in fact, perhaps they are so old that we've forgotten in some cases how useful they can be for other things besides boundary disputes, and that's what's changed. We've had the Compact Clause with us since the beginning of the country, but the use of compacts has become much more robust and has extended far beyond boundary disputes. So let's look at what does the Constitution of the United States say about compacts. Here in Article 1, Section 10, Clause 3 is what we call the Compact Clause. No state shall, without the consent of Congress, enter into any agreement or compact with another state. Now, how many of you as grammarians or students of the English language believe that that clause, properly construed as a sentence, would mean that all compacts require consent? How many think that's what that sentence appears to say? I agree with you. That's what it appears to say. However, our Supreme Court, as it has done on other occasions, has redefined certain words. And in the compact clause, any, according to the Supreme Court, no longer means all. It only means some. Only some compacts are required to have consent of the Congress of the United States, and the court has settled upon this analysis. We only need Congress to consent to a compact when the states devise a compact agreement that might infringe upon some enumerated power that was given to the central federal government in the Constitution. If the compact does not intrude upon some enumerated federal function, the states do not need the consent of Congress in order to enter into a compact. So this compact has both positive and negative implications. It's phrased negatively, but what it really means is states are free to enter into compact agreements and exercise their sovereignty to do that in order to solve problems on a uniform basis. And the only time Congress needs to get involved is when the object of the compact might intrude or infringe upon an enumerated federal power in the Constitution. And that's one of the many cases that stands for that proposition. So you might ask me, well, Rick, what difference does that make? Why do we care if there's congressional consent or not? Well, here's the primary reason. If congressional consent is required, and if it is granted, the Supreme Court tells us that that compact, which is actually a creation of the state legislatures that have passed the compact, becomes the equivalent of federal law. So Congress, by approving the compact, elevates it to the status of federal law, which then leads to the triggering of the supremacy clause of the Constitution, which, as all of you know, means that any provision of that compact, while a state statute, by congressional approval, becomes a creature that is like a federal statute or a federal regulation and would trump any conflicting state provision or state law or state regulation. So you may ask, does that mean then that congressional consent, if it's not given, that the compact is any less enforceable? And the answer to that question is no, because we also have in our Constitution the contract clause, which is also contained in Article 1, also contained in Section 10 of the Constitution, and it's in Clause 1 rather than Clause 3. And the contract clause says that states cannot impair the obligations of a contract, even a contract among themselves. And so the contract clause says that even if a compact is not required to have the consent of Congress, it will be preeminent over a conflicting state statute, which would undermine the purpose of the compact. And so once a state passes a compact statute, under the contract clause, it cannot impair that obligation that the state has entered into. And that's how we achieve an enforceable mechanism that promotes uniformity and prevents states from unilaterally changing the deal by adopting a conflicting statute after the compact has been passed by the legislature. So with that legal framework in mind, as I've said, we are not talking about an instrument that hasn't been around a long time, but we're talking about uses of compacts for things that include regulatory purposes such as healthcare professional licensure, which we're here to discuss today. But we also regulate interstate transportation through various compacts. We regulate a wide array of environmental matters. I frequently say in these kinds of presentations, show me a river basin and I'll show you an interstate compact, because river basins involve the flow of water across multiple jurisdictions, across multiple states. And in order to control things like pollution, fisheries, other management issues, even in some cases zoning around bodies of water such as lakes, have been regulated through the use of interstate compacts that have been formed on a regional basis to govern those kinds of environmental and other related regulatory matters. We also have compacts that regulate things like corrections and public safety. I'm pleased, as is Crady, to have been working on compacts that are in those areas, including the Adult Offender Compact and the Interstate Compact for juveniles, both of which have 50 state membership, representing all the states in our country, including the District of Columbia and Puerto Rico and the U.S. Virgin Islands. We also have compacts regulating educational activities, such as the more recent activity that many of you are familiar with concerning the Interstate Compact for Educational Opportunity for Military Children. And we've got Tom Hinton here today to talk a bit about that from the point of view of the Department of Defense, which actually partnered with CSG in that effort. We're also pleased to have General Steve Hogan, who's the Executive Director of that Compact Commission. If you could raise your hand, Steve. And then General Kathy Berg, who is from Hawaii, who is the chair of the Interstate Commission for Educational Opportunity for Military Children. And, I think as CSG supporters and members, we should all be proud of the fact that in the last 60 years, there are only 4 compacts in which all 50 states have enacted the compact statutory language. And guess what? All 4 compacts are affiliated with the Council of State Governments. So I think that says something about the priority that this organization gives to these devices and the way in which they are supported by our member states. So, with regard to some statistical data, how many compacts are there in the world? Approximately 215. About 40 of those are dormant or inactive. On average, every state has enacted approximately 24 compacts. Even though you're a legislator, you may not realize that your state in its state codes has done this approximately 24 times on average. Some states that total is higher, some states a little less than that, but on average about 25 compacts. There are some compacts that do involve international participation. We just had an excellent presentation on the international arena. We've got several compacts, including the Driver License Compact, in which Canadian provinces are also members. One of the earliest compacts and one of the first to engage in regulatory activity and that really started this process by which we are now regularly using compacts to engage in regulatory action was the Port Authority Compact of New York and New Jersey, which is where the World Trade Centers used to be situated, and which still is the compact that regulates all public transportation between New York and New Jersey, whether it's buses, airplanes, ferry boats, buses, subways, anything that moves is regulated by the Port Authority of New York and New Jersey if it's a public mode of transportation. They have a multi-billion-dollar budget and their own police force, and so that's certainly a good example of a regulatory compact. Here's a state-by-state analysis, and we have this data available to you online at CSG concerning how many compacts your state has adopted. And you can find in our NCIC database, and that's National Center for Interstate Compacts, not the Criminal Record Bureau. You can find in the database there information about not only how many compacts your state has enacted, but you can find the statutory citations and the areas in which compacts have been used in your state to regulate various activities. And you can note the color code here from the largest number. The green states have 31 to 40 compacts, the blue 21 to 30, and in the gray are compacts with 21 or fewer. Now, as I said, compact is not the only way that states can enter into interstate cooperation and engage in activities that involve cooperation. There are other ways states can reciprocally recognize joint regulated activities. One way is through uniform laws. In fact, Eric Fish, who is here today to talk to you about the Physician Licensure Compact Project, was formerly counsel to the Uniform Law Commission, formerly known as the National National Commission. National Conference of Commissioners on Uniform State Laws had such a long name and so confusing that we are grateful. We're thankful to God that they changed their name to the ULC, the Uniform Law Commission. But they develop uniform laws for the purpose of a wide variety of activities. The Uniform Commercial Code is a good example that regulates banking practices and checks among the states in our country, and I think virtually every state has adopted that statute and pretty much intact. And it's another way in which states agree on collectively regulating certain activities. One of the drawbacks in some cases with uniform laws is that they don't have a provision for organized enforcement by the collective actions of the states that belong. So because of that, sometimes uniform laws will be altered or modified by a state despite the best efforts of the ULC, and really nothing can be done about it. So they do suffer from a lack of enforceability, and so if the policy problem that you want to solve requires a more robust form of regulation where you've got transactions that are occurring on an interstate basis, a uniform law may not be the way to go. And we frequently have discussions with ULC, or at least on occasion, about, is this a particular activity that might be better regulated through compact, or is it less robust, and would a uniform law suffice? And then on a more narrow basis, we have administrative agreements, MOUs, that I'm sure all of you are aware of, that your states enter into with other states, and usually on an agency-to-agency basis. Again, these are very narrowly focused. They typically don't have a wide enforcement activity involved or regulatory activity involved, and are for more discrete types of agreements between states. But they are other options besides compacts. One of the reasons why a compact should be considered if you're trying to weigh the policy and make your mind up as to whether a compact might be the right solution, first of all, is there a need for a single standard? Do we want to achieve uniformity, and is there any other way to get there besides an interstate agreement which would require it? And if that is the case, then a compact certainly is a likely candidate for solving that regulatory problem. Is there a need for some economies of scale that will result from the uniform regulation of that problem by a centrally formed joint agency of the state, such as a regulatory commission, that will be charged with the duties of making sure that the compact provisions are followed the way that the legislature has directed that they should be followed? Compacts can provide within their structure, because they are contracts between states, for dispute resolution among states when there is a question of enforcement, when there is a question of whether a state is complying. And frequently we have provisions for both mediation and arbitration that are contained in these agreements. Frequently we do have situations where there is a need for state and federal partnership. The Department of Defense, quite wisely, I think, recognized when we were trying to assist military families who were moving from state to state after being deployed, when their families were having difficulties with inconsistent requirements of public school districts from state to state in grades K through 12, DOD felt, the states regulate education generally, and rather than insert the federal government's power into the sphere of state regulation of education, DOD, I think, to their credit, came to CSG and said, let's look at this in terms of an interstate compact. Do we think we can make that work? And the rest is history. We now have a soon-to-be 50 states. Governor Cuomo in New York has indicated he will sign the New York bill, and we have 49 and counting, with the state of New York being the 50th state to adopt the compact, and we're expecting it any day now, but checked my email before I came up here, and not today, but we're thankful. Other benefits that can be derived from the use of a compact, such as national data and information sharing systems. And you're going to hear from our professional regulatory colleagues today about the importance of having a national database when you're talking about interstate licensure, where multi-state licenses would be issued by states for practice of various health professions. It's critical to have a national data and information sharing system, and we do have precedent for that with existing compacts that have established those types of databases with appropriate security and appropriate programming so that they are working on a very efficient basis. You also have the ability with a compact to delegate authority for administrative rulemaking to the commission that is formed to promote the compact and to enforce it. We also have the advantage with a compact of creating boards and commissions that are joint agencies of the states, where stakeholders at the state level as well as national organizations can gather during annual meetings and other events to interface with one another concerning matters of common concern. Coordination between interstate compacts is important, and I think one of the rewarding aspects of what we're seeing here in the healthcare area is that all of these health professions, doctors, physical therapists, emergency medical technicians, even the nursing organization, which is also looking at revising their interstate compact, these groups are all talking to each other and trying to learn from each other as to how is the best way to propose a system of multi-state regulation that will work. And not every health profession is doing it exactly the same way, and you're going to find out later on this afternoon that one size does not fit all. Compacts do allow for variation as to how the compact structure will be established and how it will function. And the states are free to be creative in that regard, although once there is a decision on how to move forward, then the uniformity kicks in when the statute's adopted by the states. And with regard to rulemaking, you might be asking, is there authority for the proposition that an administrative agency that's created by a group of states that has enacted a compact statute to delegate power to that commission or agency to make rules? And the answer is yes. As long ago as the 1950s, in the case that's featured on this slide, the Supreme Court said through the mouth of Justice Frankfurter, a state legislature's ability to delegate regulatory authority to an administrative agency, including one formed by states that have adopted a compact, is one of the axioms of modern government and has been extended to the creation of interstate commissions by the device of interstate compacts. We've mentioned several of the projects with which CSG has been involved already. Two more that I didn't mention: the Midwest Interstate Passenger Rail Compact and the Surplus Lines Insurance Compact. There are a number of licensure compacts that are in effect, in addition to the ones that you're going to hear about today. And with respect to the numbers, you've got a slide here showing the 24 states that are currently in the nurse licensure compact, the 45 states that have adopted the compact on mental health. Driver licensing compact is another 50-state compact. Emergency management assistant compact, which is also affiliated with CSG, also has 50 states. And the compacts that you see at the remainder of the list here, we're going to be discussing today. The typical strategy that is used to develop these compact devices, as Bo has already said, is complex, but we've tried to reduce this to a straightforward summary on this slide. Typically, you want to make sure that you have the right stakeholders at the table in the beginning. And so an advisory commission is usually formed of groups including not only the regulators, if there are any, particularly with regard to a compact with aspects involving regulation of health professional licensure. You also are wise to include one or more legislators at the table and other officials, including those who are professionals in the area that might be regulated by the compact. Typically, a typical period of time for that advisory commission to be formed and to accomplish its work at making some broad recommendations on how policy can be addressed appropriately through the compact is a 4 to 6 month period. This can vary depending on the compact, but this is just sort of a rule of thumb to give you some idea of how this process unfolds. Typically, the drafting phase, obviously the most important aspect next to adopting it, is making sure you have a sound document that's been drafted and vetted by the proper groups that are stakeholders involved in that process. And usually, and this is an optimistic forecast, we try to accomplish that within a period of a year. Sometimes it takes longer than that, depending on the complexity of the particular compact. With respect to drafting, obviously, once that's done, making sure it's properly vetted and responded to by all of the groups that may have something to say is important. You don't always get unanimity, as all of you know, when you float an idea out there for the public to consume. Sometimes they spit it out, but it's important that they at least have the opportunity to respond and comment. You don't want to have some person that was left out of the process show up when the bill's being vetted before your committee to say, you know, we were never consulted about this, we didn't even know there was such a thing. So you certainly want to make sure that that vetting process occurs. And so this education and enactment phase usually includes additional vetting before stakeholders and groups that are interested or involved or regulated by the potential legislation, and then enactment phase, certainly to get a compact up and running with a credible number of states. Typically, the least amount of time that we have found is necessary is 18 months, and that's very optimistic. We've had some exceptions to that. I think we had the military compact, Tom, operative in 12 months because of the help that we received through both CSG and DOD. We have national advisory panels that are created at the beginning of the process, and here's just a list of bullet points that I won't spend time itemizing for you in detail, but obviously you need to make sure that the advisory panel has the appropriate experts around the table ready to look at the issue. Making a specific timetable for drafting and moving forward with the compact is critical, as is deciding how many states should be required to have enacted the compact before it is actually established as a functioning organization with an administrative agency that has some political credibility. That number is admittedly somewhat arbitrary, but I think politically speaking, we are certainly encouraging groups that are looking at a potential 50-state compact to at least have a number of states that will be sufficiently politically credible that it will be looked at as an organization that has the credibility it requires to do the regulation that is specified in the compact. And various advisory panel players that typically make up these groups, and I think you'll see in our discussion with our other experts that are here today on the various health professional compacts, all of these groups were considered and consulted with respect to how the compact would be designed and vetted. Certainly, legislative leadership, governor's offices, executive agency directors are critical players in any legislation. External stakeholders, including national associations, academic or scientific organizations, if there are any, and federal agencies, if they have a stake in the situation, as well as compact experts that have experience in dealing with these instruments. Typically, drafting team goals involve making sure that the document matches the expectations that were set out in the beginning by the advisory committee, crafting the compact based on the recommendations of the groups that designed these instruments. Establishing an adequate governing structure and specifying what types of rules will be authorized to be made is important. Circulating draft language to groups and stakeholders and states for review is important. And adjusting the compact language before it is enacted is critical.